The title of this presentation is Islamic, Anglophone, and Civilian Legal Cultures, Human Trust in the Age of Globalization. This is the abstract or introduction for a paper I presented at Chuo University in Tokyo, Japan in 2017. Chuo is one of the most important law schools in Japan. The conference was specifically devoted to the topic of human trust in the global age. Later, this paper was published in the Journal of Interdisciplinary Studies in Paris in 2018. I made a few adjustments in this brief abstract to make it more understandable. The project to construct a global regimen of law raises the question of whether human relations of personal trust continue to be relevant, especially in a technologically mediated reality of atomized social connections. Some answers may be found by comparing the role of trust in the fundamental premise of each of the three historic legal cultures: English common or Anglophone law, European continental or civil law, and the Islamic or Sharia law. In fact, the understanding of human trust works differently in each of these legal regimes. For example, the Anglophone method has a pejorative view of human nature, influenced by the old Puritan doctrine of human depravity. It trusts the human tendency to malice and greed. By contrast, the continental tradition, influenced by the 18th century Enlightenment, rests on the faculty of human reason and its potential for relations of trust, but it's skeptical of human subjectivity. Finally, the Islamic practice of Sharia places great confidence in the natural human capacities, both subjective and rational, as well as the human capacity for honesty and fairness. These differences began with the historical origin of each tradition. For example, the Anglophone method of law was born as a system of commerce in procedures of litigation. Its doctrines were based on pragmatic consensus within a fellowship of trade. By contrast, the civil law, a product of scholars and philosophers, was based on ideals and principles avowedly to serve the public good. Finally, the Islamic method of order and harmony universalized its sacred teachings by methods of reciprocity and accord, similar to what had existed in the primeval world among self-sustaining tribes and peoples. These differing assumptions about human trust resulted in different conceptions of what law was, the method it should employ, and the purpose it could serve. Each tradition operates within its population on a different principle. In contrast with one another, they represent in the English tradition faith and obedience. In the continental tradition, reason and justice. And in the Sharia tradition, justice and conciliation. In the global age, as technology penetrates national borders, transcending barriers of topography and distance, it has brought these three traditions together. The conflict arising from that encounter raises profound questions about what form of legal culture will eventually predominate, what conception of human nature will prevail, and what level of human trust will define the global future.